Morning, Prof.
Morning.
Good morning, Prof.
How are you this morning? Good.
Good, Prof. How are you?
Everything is okay. Do you know where I am? At my room at law school at Faculty of Law. I'm at my room. Sorry. You know, this is the glass, the cup. It's different. It's not a big one.
Why can you use normal glass
This
instead
is
of
my
the silver?
my room, my professor's room at Faculty of Law. One day you can visit. You can visit this room when the corona is over. Okay. We are waiting for another sorry, we are waiting for others. Okay, shall we begin?
Yes, Prof.
Okay, while we are waiting for the others, I think it'd be better that we begin this class. Okay. I guess we have discussed this case. A coffee shop owner places a menu list of various hashes and marijuana with their respective website. We have discussed this topic, haven't we?
Yes, we did.
Okay. The solution is whether or not placing announcement or any other information on the website at public means a public dissemination. Whether or not placing announcement or any other information at websites means a public dissemination. You know, public dissemination. To publish. To publish mean to public dissemination. We answered this question.
Yes, we did.
Yes. Judge at the Supreme Court, I guess, in the Netherlands, or the Dutch Supreme Court, regards website as public area. So it is public dissemination. Notwithstanding, despite that placing information at website is not provided in opium law, it is a crime when information contains prohibited items. So websites seems to be a public area. Oh, sorry. Website is considered to be a public area. This is the judge decision in the Netherlands. Now, well, I guess I have made it. Until this topic, I guess, we've discussed it. The petitioner is recognizable in a few records that they are shown in the program, and no image or sound distortion is used. Okay, we have discussed it. Okay, now I have to arrange. Okay. Okay, look at this story again. That Supreme Court decision of February 24, 2017, just recently, only two and sorry, 3 years and 8 months ago. This is a story. On May 27, 2012, SBS6 showed an episode of program under the title Crime Reporter, directed by Peter R. de Vries. Okay, this is the program shown in the TV, a TV program. In the episode, in camera images, a discussion was shown between the prisoner and someone suspected as an assassin, which is Jennifer called A, about the best way to eliminate a competitor in sex business. You know, in the Netherlands or in the United States, there's a sex business. I think it is not allowed in Indonesia. Sorry, I have to read a message. Okay. The petitioner is recognizable in the video records that are shown in the program, and no image or sound distortion is used. His full name was not shown. However, but I think the word however is more formal than but. In writing, I guess however is um it's better than but. But sometimes I also use but for to avoid the readers getting bored. However, the initials of his first and family names were made known. So I've told you last Monday that my name is Peter Mahmud Marzuki. And in this case, perhaps the director of the program only assigns my name, for example, P. Marzuki. P. Marzuki. So perhaps there's another one names P. Marzuki, Purwanto Marzuki, Prasetyo Marzuki, Pungki Marzuki. There are many people named P. Period Marzuki. You know period?
Yes, sir.
Yeah. In British English, it is called full stop. In British English, it is called full stop. Well, it reminds me to my Indian friend in the United States, and the professor told us period, and he raised his hand. What kind of period, sir? And you know, the professor asked him, "What do you mean by your question?" The Indian friend, "You said period. You said period, sir. So what kind of period?" "No, I don't understand what your question is." Well, I told him, Aswani Goel, Aswani, you know, period in British English, full stop. "Oh, sorry, professor. You mean full stop? What?" Now the professor confused. What is full stop? So please be careful. If you're trained in British English, perhaps you have to adjust with my words. For example, I always say restroom. But British English is toilet. It is French word toilet. Toilet. You know toile. Toile in France, toile is towel in English. Towel is toile in France. But étoile is star. Étoile is star. And if you go to Paris, you can see étoile, the goal. The goal, you know, the goal. He was the president of France, president de Gaulle, Charles de Gaulle. Charles de Gaulle, étoile de Gaulle means the gold star, the gold star. So this is what I was confused when I was in New Zealand. In New Zealand at that time, I was designated to stay at room number 700 something. I know that it is a 7th floor. I asked the receptionist, "Is this hotel equipped with elevator?" "No, sir." "So, how can I go upstairs?" "Well, you use lift." "Oh, I see, lift." Because you know, when I returned from the United States, that's my English is American, and I work in Jakarta. I was a sorry, expert staff to the Ministry of coordinating Ministry of Economy and Development Supervision at a time, and I work with Americans, and every day we speak English. Every day, because my counterpart is American. Of course, American English. And when we went to New Zealand and other countries, we were together with American. One of them is American. So you know, I'm accustomed to speaking American English instead of British English. Okay. His full name was not shown. However, the initial of his birth and family names were made known. On August 15, 2012, the prisoner was sentenced to 6 years imprisonment for being guilty of an attempt to incite the assassin to commit murder. Why? It's not to a 6-year imprisonment. No, it is not the I mean, it is not a provision. It is sentence. It is verdict. It is verdict. You know verdict? Verdict is I mean, verdict is a judicial decision. Is verdict. Judgment. Verdict. The prisoner was sentenced to 6 years imprisonment for being guilty of an attempt to incite the assassin to commit murder. To incite. You know, to incite.
Yes, sir.
Yeah. Okay. He was declared guilty based on evidence in the form of the pictures from A. So this is the evidence. You know, evidence
Yes.
in Indonesian criminal process law, or in now we have a code on criminal process law. What is called KUHAP, Act number 8 of 1981, Act number 8 of 1981, which is KUHAP, criminal process code. You know, witnesses or witness is evident. Expert, I mean, not expert. Expert statement. Yeah, expert statement is also evidence. Document is also evidence. Defendant's statement, well, it is not defendant's confession, but defendant's statement. Please be careful. It is not defendant's confession, because at a time when the criminal process code was drafted, the expert from Erlangga University Law School at the time, Pak Suharyo, I still remember this idea. He rejected confession laid down in the KUHAP at the time. He strongly rejected. Why? Because to give confession, sometimes the defendant or the accused was tortured, you know, tortured, because the defendant is tortured in a detention house, then defendant is forced to confess. So Pak Haryo at the time rejected that confession is laid down in the Ruhab. I still remember why he strongly rejected such a provision, and I guess um, his idea is accommodated by the House of Representatives at the time, and then it's okay. Now, confession is not laid down in the in our criminal process code. The mass media organizations had made reports on the sentence and Peter the Fish program previously. Have you ever seen Jessica's trial broadcast by TV?
Yes, Prof.
Yes, sir.
Yes, Prof.
Three years ago, I guess. 3 or 4 years ago. 3 years ago. Well, as a jurist, as a lawyer, I don't agree with such a broadcast. I don't agree. I think it is inappropriate, especially for the witnesses. You know that every witness should be separate from another. And if a witness saw the TV, he also can perhaps arrange a story to defend or to defend or to challenge. This is my objection. So in ancient case, inspired an author to write a book published in 2013. Maybe if there's a bill concerning Jessica's case, well, it is not allowed to be published because, it is personal. Oh, it is a privacy. It is privacy. Well, privacy should be honored. Everybody has privacy. So this is my idea that privacy should be honored. Whoever he is, still remember my lecture on existential aspect of a human being. Still remember that? I hope that you remember my lecture. I think the third or the fourth week. I'm not sure, but I guess that it was the earlier before midterm. So everybody has privacy. 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 It is should be honored. Everybody has privacy. In the book, it is stated that the murder actually happened. In the book, it is stated that the murder actually happened. Yeah. Like Jessica's case, the murder was really happened. That Mirna was murdered by whom? The petitioner full name is cited as the murderer. This is against privacy. This is against privacy. The petitioner's full name is cited as the murderer. What about if the author attended the trial? Is it permitted to cite the murderer's full name? Ora,
No, don't think so.
suppose the author attended the trial.
Yeah, I still don't think it's allowed because it's still his privacy.
Is it allowed to cite his full names?
No.
Unethical.
Gabriel?
It's unethical, I think.
Okay. So it is not allowed because it is privacy. So, before being a professor, when I was a student, since I was in the elementary school, I wrote some short stories, of course, for children when I was in elementary school. Then until I think until 1980s, when I was a lecturer, I still wrote such stories in newspaper. And then there are some real story. There are some true stories, but I have to change the characters into the characters that their names into the name that I've given. So, and then I have to modify the true story into something that make the reader being more interested in the story. They were not my own experiences, but sometimes I know my friends' experience, and I ask her or him whether or not that I'm permitted to write a story, and they allowed me to write, provided that their names are changed. Well, in this case, I guess, as a writer, I said to you that is unethical and it is against privacy. So perhaps sorry is okay, but the full name is not allowed to be cited. So the the character James Bond is character. Mr. Bean is character. Have you ever seen Mr. Bean?
Yes, Prof.
Mr.
Yes.
Bean is a character.
Rowan Atkinson.
Character. Mr. Bean is character. Mr. Bean is Rowan Atkinson. So Rowan Atkinson stars as Mr. Bean. Mr. Bean is a character. Whereas in wayang, Berkudoro is also a character. And character is a person in a story or in a film. It is character. But if you read Saul Bellow, Iwan Simatupang's novel, there is no character in it. This is literary. I like literary, I like poems. I like American poet Emily Dickinson, William Carlos Williams. I read their poems. So I like American poets. And there's also English poet, Walt Whitman. His book is good. Leaves of Grass. Leaves of Grass. So I like poems, film, music, soccer. Soccer, music, film, poems, novels, and flowers. Flowers. My wife's name is Flower, Lily. Lily on the Valley. Have you ever heard the song Lily on the Valley? Lily on the Valley and the morning star. This is Lily on the Valley. When someone types the petitioner's full name in a Google search, the name promptly gives rise to the websites of Amazon.com, Google, book.google.nl. What is NL?
Netherlands.
Netherlands. Indonesia? ID.
IN.
USA?
Yes.
US. Australia?
AU.
EU. Singapore?
SG.
SG. Malaysia? MY. United Kingdoms, UK.
Yes.
So you have to know. India.
HI.
Sorry?
HI.
India? Are you sure?
Stanford, right? I don't know for sure.
New Zealand, NZ. This is Netherlands. Amazon.com. It is very well-known bookstore. Amazon.com. I think the first soft bookstore is Amazon, or I think the first bookstore in website is Amazon. Then there are many bookstore. Book.google.Netherlands and ebooks.com. That contains the book that was published in 2013. And the Algemeen website. Algemeen is Dutch. In English, it's general. But it is the name. It is the name of the website. Algemeen. Algemeen means general. Algemeen website that contains news about the murder published by mass media organizations. Algemeen. So in Indonesia, we have Algemene Bepalingen van Wetgeving, or abbreviated as AB. AB, Algemene Bepalingen van Wetgeving. Well, I think it should be translated into Algemene Bepalingen, general provision van Wetgeving. Wetgeving means legislation, general provision of legislation, or we call it general provisions of law. Algemene Bepalingen van Wetgeving. Algemeen website that contains news about the murder published by mass media organization. It is really against privacy. It is really against privacy. The privacy should be honored. Okay, I have to arrange again. Okay. The petitioner attorney lobbied Google to cease to display the URL of the petitioner's full name from the designated websites when anyone types the petitioner's full name in the Google search. You know, attorney at law. So attorney means attorney at law. But there's also okay.
Sir, what is the difference attorney and lawyer?
Well, okay, that's good question. I will tell you later. You know, attorney. Your question is, what is the difference between attorney and lawyer? You know, every lawyer can be attorney at law. If I represent someone, at a trial, or represent someone to negotiate, I am his attorney. Attorney is someone who is in what I say, in doing his job. In doing his job, it is attorney. So, for example, PD Penggandaan authorizes us to be attorney to represent the company to negotiate with other company, for example. We are lawyers. In this case, we do our job as attorneys. So lawyers can be attorney. So in the United States, for example, there's a patent attorney and patent consultant. Patent consultant may be someone, say, an engineer, for example. But patent attorney should be lawyer. Lawyer who represents his or her client. Maybe he or she is called attorney at a time. But in the United States, a lawyer who defends or who represents his client in trial, he or she is called counselor. So in the Netherlands, perhaps he or she is called advocaat. That in the United States, when someone represents his or her client before the court, he or she is called counselor, not lawyer. But when a lawyer represents his or client to negotiate or something, maybe he or she is called attorney because there's a power of attorney. And with the power of attorney, the lawyer can represent the client in trial, and he or she is called counselor. Okay. Now we have to know Attorney General. The day before yesterday, or yesterday morning, Monday, when? Oh, Monday, the day before yesterday, Monday. Now it's Wednesday, isn't it? Okay. Last Monday, when Joe Biden's victory was certified by the Electoral College, U.S. Attorney General Barr resigned. So what is Attorney General? Indonesian Attorney General today is Hasanuddin. TB Hasanuddin. Tubagus Hasanuddin. Attorney General. You know, the Attorney General office in Jakarta is close to what is Jalan? Well, I guess Jalan Hasanuddin. It's by accident that the Attorney General today is Hasanuddin, and the Attorney General office is on Jalan Hasanuddin, I guess, close to Block M. Hasanuddin. You know, Attorney General. The late Deputy Attorney General is graduate from Erlangga University, but not the Attorney General. There are Attorney Generals since independence. There are 3 Attorney Generals graduate from Erlangga University. Singgi, Attorney General Singgi is graduate from Erlangga University. Then there's Sujono, and the last one was Muhammad Abdurrahman, Wisma Juris. He was Attorney General under the Megawati's administration at the time. So 3 of Attorney Generals in Indonesia were graduate from Erlangga University. In the United States, there's district attorney. I guess in Indonesia, there's also we call it whether district attorney or what I see, because in addition to district attorney, there's also what we call provincial attorney. So attorney is different from lawyer. Attorney is also the public prosecutor is also attorney. The petitioner attorney, this means that the lawyer of the petitioner lobbied Google to cease to display the URL or the petitioner full name from the designated websites when anyone types the petitioner full name in the Google search. You know that the the attorney tried to settle the case outside the court, or we call it out of court settlement. Is it okay? Well, I guess in Indonesia, if it is civil procedure, if it is civil case, it is possible that the petitioner revokes the petition when the respondent agrees about the conditions offered by the petitioner. Even in their industrial relations case, in Indonesia, the court always begins with negotiation first, amicable solution first. Amicable solution. Amicable solution means that the solution is made by the parties themselves. Amicable solution. Okay, well, we are friends, we are relatives. So, okay, I don't want to continue bringing the case to the court. Okay, what about if I offer this condition? Okay, I accept your order. I accept your offer. And then shake hands. It is amicable solution. In my when I draft a contract, if I draft a contract, I always put in the first paragraph of the dispute resolution that every controversy, every dispute, or any dispute or controversy arising out of or in relation to the contract will be settled amicably by the parties. This is the first paragraph that I've drafted in my contract, in a contract that in a contract. You know, I'm a contract drafter, especially business contract, international business contract. In a dispute resolution, I always put such a clause. Any dispute, controversy, or difference arising out of or in relation to this contract will be settled amicably by the parties. And paragraph 2, in case the solution carried out by the parties does not produce settlement, so the party blah blah blah. That's so I always put amicable solution as a clause in a contract to settle dispute. I think the lawyer tried to lobby Google to cease to display the URL or the petitioner's full name from the designated website. Google, however, refused the request. So the negotiation was deadlocked. You know deadlock? Deadlock?
Yeah.
Deadlock.
Yes, sir.
Deadlock means no solution. Deadlock. Not lockdown. Deadlock. Google, however, refused the request. But first, an appellate court dismissed the petitioner's claim. You know, in the Netherlands, the first instance or district court, like in Indonesia, is called rechtbank. Rechtbank. This is the first instance of trial. And the appellate court is called Hoogrechtshof, or it is abbreviated as Hof. And the Supreme Court is Hoge Raad. Hoge Raad. It is in Hoge Raad, is in The Hague. You know, The Hague is not a capital of the Netherlands, but you know that the Hoge Raad, the Supreme Court, is located at The Hague, and also embassies are located at The Hague. Most embassies, like Indonesian embassy, is at The Hague. The Hague in Dutch is Den Haag. Den Haag. Den Haag, The Hague, The Hague, or in France, La Haye, La Haye, The Hague. Okay, it's not, well, this, The first instance court, first instance court, as I've told you, in the Netherlands, it is called rechtbank, the district court. The first instance court ruled that the petitioner has been charged with a severe felony and has been declared guilty by the trial court. The first instance court ruled that the petitioner has been charged with a severe felony and has been declared guilty by the trial court. In crime, maybe differentiated by felony and misdemeanor. Okay. Again, crime may be differentiated into felony and misdemeanor. Felony is a severe crime. Misdemeanor is lighter one. In our penal code, felony is laid down in Book 2, and misdemeanor is laid down in Book 3. Felony is severe crime. The first instance court ruled that the petitioner has been charged with severe felony and has been declared guilty by the trial court. Excuse me, I have to charge this computer, otherwise it will be off. It's okay. Therefore, is no right to be protected from the Google search results. Because he has been charged with severe felony, he has no right to be protected from the Google search results. This is the opinion of the first instance court of the district court of rechtbank in the Netherlands. The public, therefore, can relate him to the crime. Well, in my opinion, the decision is inappropriate because it deals with privacy. Again, I don't know why it's like this. Consequently, there is no ground to order Google to remove its name from the Google search results. This is the consideration. This is the reason. This is the sorry. The reason is because the petitioner has been sentenced to um, something years imprisonment. He has no right to be protected by Google. So consequently, there's no ground to order Google to remove his name from the Google search. In this case, the court is faced with opposite interests. Don't say opposite, opposite. Well, target, not target. To get, not to get. To get, I get. Target. Okay, I get. Target, not target. You have a target. What's your target? Not target. Prejudice, not prejudice. Please be careful. Sword, not sword. Sword. You know sword? For fencing. In this case, the court is faced with opposite interests. This is philosophical conflict. The personal data of an individual and the public interest to obtain information about the individual and the economic interest of the search engine. There are three kinds of interests. You know, the personal data of an individual should be protected. But the public interest to obtain information about the individual, well, should be granted. And the economic interest of the search engine should be served. There are three types of interest are in conflict in this case. This is the law. You study about the conflict. Or to draft or to prepare to avoid a conflict. So again, In this case, there are three types of interests which are in conflict. The protection of personal data of individual, for example. The public interest to obtain information about the individual, which should be granted. And the economic interest of this search engine should be served. Okay. So the court should decide which interest should be referred to as a decision. Which interest is in highly valued by the court. The court needs to evaluate which interest prevails over the other. The Supreme Court granted the petitioner claim and imposed a penalty on Google, sorry. The court needs to evaluate which interest prevails over the other. The Supreme Court granted petitioner claim and imposed a penalty on Google. So